Marcellus Williams is scheduled to die in Missouri for a crime that he did not commit. He's been on death row for over 20 years now, and he is scheduled to be executed in exactly 6 days. So I want to go over the story with you, let you guys know what's going on, and then tell you how you can help to get him off. So hit the like button, hit the subscribe button. Be sure to share this video with everyone you know. This is a very important matter. So Marcellus Williams is a man facing execution in Missouri despite DNA evidence proving his innocence. The Circuit Court of St. Louis County, Missouri scheduled a hearing for August 21st, 2024 to assess the clear and convincing evidence of actual innocence that led prosecuting attorney Wesley Bell to move to vacate Williams's wrongful conviction of death. So this man was prosecuted by the state. The state realized their error and has moved to have this case dismissed, or to have this case vacated. The St. Louis County prosecuting attorney reviewed these DNA results and filed a motion to vacate Mr. Williams' conviction because he believed the DNA results proved by clear and convincing evidence that Mr. Williams did not commit this crime. So here's some of the case facts. A crime scene covered with forensic evidence contained no link to Mr. Williams. Mr. Williams has been seeking to prove his innocence throughout the 23 years he spent on Missouri's death row. On August 11th, 1998, Felicia Gale, a former reporter for the St. Louis Post-Dispatch, was found stabbed to death in her home. The perpetrator left behind considerable forensic evidence, including fingerprints, footprints, hair, and trace DNA on the murder weapon, a knife from Mrs. Gale's kitchen. None of this forensic evidence matches Marcellus Williams. So we are very well aware of the plethora of cases involving Black men that have purported to accuse them of crimes that they have not committed, whether it be murder or theft. And many of these men, unfortunately, have either spent the rest of their lives in prison, have been executed, or are still fighting these cases. And so that's why this case is so monumental, so pivotal. There have been plenty over the years. And it's not a good thing that there have been plenty, obviously, but we have another chance to get this right. So the prosecution's case against Mr. Williams was based entirely on the unreliable testimony of two incentivized witnesses. So the case against Mr. Williams turned on the testimony of two witnesses who were incentivized by promises of leniency in their own pending criminal cases and reward money. So basically, they were offered reward money to give up facts or details about Mr. Williams, true or untrue, in exchange for money and reduced sentences in the cases that they had pending with the state. The investigation had gone cold until a jail inmate named Henry Cole, a man with a lengthy record, claimed that Mr. Williams confessed to him that he committed the murder while they were both locked up in jail. Cole directed police to Laura Asaro, a woman who had briefly dated Mr. Williams and had an extensive record of her own. Both of these individuals were known fabricators. Neither revealed any information that was not either included in media accounts about the case or already known to the police. Their statements were inconsistent with their own prior statements, with each other's accounts, and with the crime scene evidence, and none of the information they provided could be independently verified. Aside from their testimony, the only evidence connecting Mr. Williams to the crime was a witness who said Mr. Williams sold him a laptop taken from Ms. Gale's home. But the jury did not learn that Mr. Williams told the witness he had received a laptop from Laura Asaro. So the jury didn't even have that information to make a decision on. Also, another note is on the jury for Mr. Williams's initial trial, there were, I believe, you have 12 jurors, 11 of them are white, and only one was Black. And there were Black jurors that were dismissed from the case during the jury selection process. We have to wonder, you're supposed to be judged by a jury of your peers. He's being judged by people who don't know him, who are not familiar with his culture, who don't know his surroundings, they can't relate. It's unconstitutional. You're supposed to be judged by a jury of your peers. So new DNA testing confirms Mr. Williams is innocent, yet no court has considered this evidence. As he fought to prove his evidence, Mr. Williams has repeatedly faced imminent execution. To date, no court has given him substantive consideration to the evidence exonerating him. In 2015, the Missouri Supreme Court stayed Mr. Williams' execution and appointed a special master to review DNA testing of potentially exculpatory evidence. Exculpatory evidence is just evidence that shows that you haven't committed a crime. In 2017, after the testing was completed, but without conducting a hearing or making any findings based on the outcome of the testing, the appointed special master sent Mr. Williams' case back to the Missouri Supreme Court. That court, also without considering the DNA testing evidence, again scheduled Mr. Williams' execution. So his case has been reviewed now by a special master that was assigned by the court to review the evidence. And the testing was completed, but they didn't conduct a hearing or make the findings known based on the outcome, right? So once you review something, you're supposed to write a report, make a memo, and have it forwarded to the appropriate authorities to review your findings. This was not done. So recognizing that the new evidence raised serious doubts about Mr. Williams' guilt, the then governor, Eric Greitens, stayed the execution and convened a board of inquiry to investigate the case on August 22nd, 2017. He's just being run through this circus, this arena. We have no indication of when it will end. So in 2024, the St. Louis County prosecuting attorney concluded that Mr. Williams was actually innocent and moved to vacate his conviction. So after the exculpatory DNA evidence was brought to his attention, St. Louis County prosecuting attorney Wesley Bell appointed a special prosecutor to review Mr. Williams' case. The special prosecutor reviewed the findings of 3 independent DNA experts. All 3 concluded that Mr. Williams was not the source of male DNA on the weapon and therefore could not have killed Ms. Gale. Mr. Williams' exclusion from the murder weapon is consistent with his exclusion from other forensic evidence collected from the crime scene, including a bloody shoe print and hair found near the victim's body. We have to ask, the St. Louis County prosecuting attorney, Wesley Bell, is saying that, hey, this guy, from what I'm seeing, there's no evidence that this guy was even at the crime scene. Why is it that his execution is continuing to be stayed by St. Louis representatives? It doesn't make sense to me. By St. Louis County representatives, it doesn't make sense to me. So although the prosecuting attorney's motion remains pending and the law requires the court to hold a hearing on it, the Missouri Attorney General has taken the position that Mr. Williams' innocence does not matter, and the Missouri Supreme Court has scheduled his execution. So the Missouri Attorney General's office has argued in other death penalty cases that even DNA evidence of innocence is not enough to stop an execution. Jailhouse informant testimony like that leading to Mr. Williams' conviction is one of the leading contributing factors of wrongful convictions nationally, playing a role in 15% of the 598 DNA-based exoneration cases. 11 of the 54 individuals exonerated in Missouri were convicted with the use of informant testimony. You have people who are just flat out lying on an individual that causes this individual to be convicted of a crime and sentenced to death. We find out that these individuals are lying. We find out that they were paid, and there's still no recourse to rectify this situation. And this is supposed to be the American legal system. So Mr. Williams, a black man, was wrongfully convicted of murdering a white woman. His jury was comprised of 11 white people and only 1 black person. The prosecutor, whose institutional practice of racially discriminatory jury selection has been widely documented, successfully removed 6 of 7 qualified black prospective jurors with peremptory challenges. So a peremptory challenge is essentially the right of the state or an individual to remove jurors without giving a reason as to why the juror is being removed from the case. So you could just say, these people over here are black, they're going to vote in favor of this guy here, so let's kick them off the case, let's get some white people in. You can do that. It's unfortunate. There are some legal avenues that you could take to, fight against unfair peremptory challenges, but I'm not sure that happened in this case. A recent study of 400 death-eligible cases in St. Louis County over a 27-year period also revealed racial disparity in the use of the death penalty based upon the race of the victim. People who were convicted were 3 times more likely to receive the death penalty if the victim was white, as in this case, compared to if the victim was black. So that tells you people are getting the death penalty or getting accused of murder at much higher rates when the victim is a white person versus if it's anybody else. And just so we know what kind of individual Marcellus Williams is, during his 23 years in prison, Mr. Williams has devoted much of his time to studying Islam and writing poetry. He serves as the imam for Muslim prisoners at Potosi Correctional Center and is known as Khalifa, meaning leader in Arabic. There's a petition that you can sign to help get Mr. Williams exonerated and to avoid his execution, which again is supposed to happen in just 6 days. So I'll share the link in the description for the petition. You can also share Mr. Williams's cases on social media channels, and I'm going to leave a link to this page as well. And you can use your voice. Create an Instagram page or Instagram post, create a TikTok post, make a YouTube video. I saw Rashad Richey's Indisputable coverage of this case, and it inspired me to make a video and to give you guys some of the facts of the case. I'm not a lawyer, but I have a little bit of legal understanding from just my reading. It's classes that I've taken, but you don't have to be a lawyer to see injustice, okay? Marcellus Williams, he's not on any of the evidence. There's no DNA evidence linking him to the crime. There are 2 people who are known liars that said that he did it. Those 2 people know each other and they were paid money. Governor Parsons, I believe his name is Governor Mike Parsons, has the ability to completely commute this sentence, and he won't do it. Definitely check out the links in the description box and get active if you can. Do something to make sure that this man does not die. The evidence does not point to him. Either way, no matter how you feel about criminal punishment and the criminal justice system, there are ways to deal with people that commit crime that does not involve murdering them. Gail's family even said that they don't want this man to die. They've signed a petition saying that they want him to live. So there should be no issues. If the law is also created to redress people who have been harmed, then these people are clearly saying, and the family of the murdered woman is clearly saying that, hey, look, we don't think that either don't think this is the guy, or, but at the very least, we don't want him to die. So the people in Missouri, the legal officials in Missouri should be taking note of the wishes of the family. Anyway, thanks for watching. Peace.